So my name's Ken Vercammen, and I'm going to talk something about the major laws in drug DWI, and touch upon it in a way what's going on. So people says, hey, what's going on? Well, okay, for many years the legislators tried to enact marijuana decriminalization, and they couldn't get the votes, so they put it to the voters of the state of New Jersey, because the senators couldn't agree. New Jersey voted in favor, and there was a lot of give and take, because the senators in the cities wanted it to be as liberal as possible. So let's start off. Okay, what can you have? Okay, well, you can no longer be prosecuted if it's simple possession of 6 ounces or less of marijuana. You can no longer be prosecuted for being under the influence of marijuana. There's also a statute that was called failure to dispose of drugs, and and you can't be prosecuted for that. You can't be prosecuted for paraphernalia for marijuana. Under the statute, bongs were illegal. You can be prosecuted for having syringes or cocaine utensils, and they also got rid of the possession of marijuana in a motor vehicle, which was a 2-year loss of license. So now also under the statute, distribution was lessened, for the purposes of marijuana. So the law creates new framework for individuals who possess with the intent to distribute 1 ounce or less of marijuana. First offense, it's simply a written warning to individuals, and law enforcement has to build a mechanism to track warnings. Second offense of distribution of 1 ounce of marijuana, then they get a summons under the new complaint. They can't be locked up. Why is it just one ounce to distribute, but you can own 6 ounces? Well, some people were rolling up a whole bunch of joints and selling them on the corner. They don't want people selling joints on the corner. You really want, the state wants their tax money, and eventually they're going to have distribution places licensed by the state, similar to the medical marijuana. Now, also under the law, the odor of marijuana, either smoked or raw, by itself no longer establishes reasonable articulable suspicion to initiate a stop or search of a person or their vehicle to determine possession or fourth-degree distribution. If they smell enough weed that it's 2 pounds of weed, then they can do it. Marijuana, unburnt marijuana has that skunky smell from college. But the reason why they put that in there is because when cigarette smoke has a stench, and marijuana smoke has a smell. And people, someone could have smoked marijuana a week before, but their clothes, their jacket still smelled the weed, or the car smelled the weed, and the police were, searching cars where there wasn't any weed in for, possibly a week or so at the time. Now, number 4, there's special rules for persons under the age of 21 for pot. So because the legislators in the city said, hey, listen, our people are being targeted, etc. So, so they basically, for under 21s, it's almost a freebie for possession of marijuana, cannabis, or alcohol in a public place, including a school. So for a first offense, the police officer just gives them a written warning, and also notifies their parents, but they're not arrested. Let's see. Second offense, written warning. They're provided information on drug treatment. The parents are notified, but they're not arrested. So now, let's say the Attorney General's office, once the law was signed by the governor to be effective in February, had AG Directive 2021-1, and it also gave guide, what the police can do, but it also instructs state, county, municipal prosecutors to dismiss any charges that were pending as of February 22 for any marijuana offense because it was no longer illegal under the state. I had a kid that was 18, had a pot charge, and I said, hey, listen, let's delay this. If it gets legal, we're good. Okay, it's signed, and then the case was scheduled for April, and then the court said, oh, we're going to put this off until June. I goes, no, absolutely not. We have a directive from the Attorney General's office that the municipal prosecutor is to dismiss the charges, now, not wait till June. My guy doesn't want this on his record. Okay. Now, number 6, the Attorney General directive addresses pot cases that are already resolved or where there was a conditional discharge. Now, what a conditional discharge is for first offenders on pot or on drug cases in municipal court, you stay out of trouble for a year, you pay some penalties, but then at the end of the year the charge gets dismissed. Well, the Attorney General's directive is that that any guilty plea is supposed to be vacated by the administrative office of the courts. If they pled guilty to something, it's supposed to be vacated. Probation ends. They no longer have to pay any court-ordered financial assessments or fines. They're not getting their money back, by the way, but they no longer have to pay any further financial assessments. So, under the Attorney General's directive, what should the police officer do if they smell pot coming from a vehicle on a motor vehicle stop? Well, first, the police officer has to determine, is there probable cause to believe that the driver is operating the vehicle while under the influence? Because, it's illegal to operate under the influence of any kind of drug. And if they are believed to be under the influence, the driver can be arrested and then the vehicle searched. However, if they do field sobriety tests and they find the driver is not under the influence of, pot or, alcohol, the new laws are clear that the odor of marijuana, either burnt or raw by itself, does not establish reasonable suspicion to justify a continued stop, nor probable cause to conduct a search of the vehicle or the person. In these marijuana possession or low-level possession with intent to distribute. Therefore, as a result, the Attorney General directed that the occupants must be released. They can't be held further. Now, let's say it's not in a vehicle. Someone's in a park. Or they're at a concert. Okay, and the police smell weed. May the police initiate or continue a pedestrian stop of an individual based upon the officer detecting the odor of marijuana? The answer is clearly no and oh. So that's the that's the law. People can go to concerts, they can smoke their weed in the car and then in the parking lot, and the police can't search them. Now, there's special rules though for people under 21. What can't the police do? Well, they're pretty much hamstringed. The new law prohibits law enforcement from engaging in certain actions for people under the age of 21 for possession of marijuana, hash, cannabis, or alcohol. And there's a section where if the officers do charge people improperly, they can be criminally charged themselves. So the officer cannot ask an individual under the age of 21 for consent to search, the car or the person, unless they can ask for consent to search if they believe, bona fide criminal activity is afoot, burglary, real crimes. And again, the odor of alcohol, marijuana, does not give suspension to stop 16, 17, 21-year-old, so they can't search their person or property. Another law that didn't make the newspapers was magic mushrooms are no longer a felony indictable offense in 2021. Instead, it's a disorderly persons offense that's heard in the municipal court. So, now, you can't if you're making money selling and there's a lot, you can still be prosecuted. But the idea was to make the routine drug cases for pot decriminalized. And I remember serving as a defense attorney, hundreds of times, and talking to cops. I goes, why are you busting this guy? All he does is a small amount of weed. He's not driving. And even talking to some of the police, he goes, hey, listen, I'd say, how many times have you ever been called to a domestic violence altercation and someone was smoking weed? Zero. They should give weed to all the drunken troublemakers to mellow them out. I represented a 17-year-old that was charged with possession of a small amount. They were smoking. Him and his buddies were smoking a joint. And the prosecutor's like so high and mighty. We got to the drug menace. I goes, drug menace. Listen, this kid smoking a little bit of weed. He's the captain of the all-state volleyball team. He's already accepted into good college. He got 800 on the math SAT. They should give some of his pot to the not as smart kids. Maybe it must be super smart pot. And remember the prosecutor saying, imagine how well he'd do if he didn't smoke pot. No, he'd probably do worse because, the pot would, mellow people out. It would help them sleep, calm people down. Obviously it hurt my business as far as like being an attorney making money, but the legislature did the right thing. Okay, now let's talk about the big changes in the DWI law. Prior to a year and a half ago, if for a DWI, unless it was a real low reading, I would say, hey, listen, you're almost guaranteed to lose your license for 7 months. Under the new law, the idea is they want to have to protect the public rather than having people lose their license for long periods of time. As long as they install this thing called an ignition interlock on the vehicle that they own, then they have substantially less suspension. So let's say the person has a reading of 0.08 to 0.10 alcohol level, okay? Instead of having a 90-day loss of license, I'd say if they have the interlock installed and installed for 3 months, as soon as they go to court and have it installed, then they get their license back. Let's say the reading is 10 to 15, okay? They have to get the interlock on. Their license is suspended when they go to court, and once they present proof that they have the interlock to the court in motor vehicles, then they get their license back, and they got to keep the interlock on between 7 months and 1 year. So logistically, if someone has a DWI, but they have a good attorney get the interlock, they can lose their license for as little as a day, because they get the interlock installed the day before court. They have proof. It's sent to the court ahead of time. Because we try to do as many things as possible. We email it to the prosecutor ahead of time, email it to the court. Okay, the court does that. Some courts are reopening to humans soon. They get the order from the court, then they go to motor vehicles. Some motor vehicles you got to make an appointment. Then they get it as long as they have the interlock on. Now remember, you can't drive a car unless it has an interlock on. It's not only your car, but any cars you operate. So if you have several cars, you can't operate those cars unless you have the interlock. Let's say the reading's higher, 0.15 or higher. Instead of losing your license for 7 months to a year, you lose your license for 4 months to 6 months. Then you have to have the interlock on for between during the license suspension period, and between 9 and 15 months further. On a second offense, the loss of license used to be 2 years across the board. Didn't matter if it was an .08 or a .15. Now, for the purpose of you have the interlock put on, then the loss of license, there's discretion the judge has between 1 year and 2 years, but then you still have to have the interlock put on for the loss of license period of 1 year, 1 to 2 years, plus an additional 2 to 4 years afterwards. By the way, the interesting thing was the Mad Mothers lobbied the legislature to put this through, partly because the interlock companies donated money to the Mad Mothers. Let's say someone doesn't have a car. Well, okay, you don't got a car. You certify to the court, I don't got a car. Well, you're not home free. Then you don't have to spend the money in interlock, but then you'll lose your license for the full regular period of time. So let's say someone had a low reading. Okay, they lose their license for 90 days. Let's say the reading is a .10 or higher. Well, then you're losing your license for 7 months to 1 year on that first offense. Let's say it's a second offense. You don't own a car. Hey, you're losing your license for 2 years. On the third offense, people, the real alcoholics, they reduce the loss of license from 10 years to 8 years, and then also you have to have the interlock put on during that 8-year loss of license, plus 2 to 4 years afterwards. Now, one of the reasons also why they wanted this interlock thing rather than loss of license is for revenue reasons, and revenue meaning people that work pay taxes. People that are on welfare and don't work don't pay taxes. Now, the analogy was New Jersey, for some people that were locked up, created something that was called work release, where someone was a non-violent offender. They could be there for let's say a theft charge or a drug charge. They were locked up, non-violent offense. They could be released from jail that morning. They could work during the day, and then they're released, release, to their regular job, and they can go back. Then they would go back to jail at night. And the reason why the legislature enacted this is so that people who are working pay income taxes. People that are working pay their child support. And then on the other hand, people that aren't working aren't paying child support. And then the mothers of the children would apply for welfare, so welfare was paying. So the idea was working people pay property taxes. Now there's still potential jail. On a first offense, you still could go to jail for up to 30 days, but unless someone was really high reading and, let's say, a jerk to the police and a jerk to the court, some judges say, I'm going to give you 30 days, but your attorney has convinced me to suspend the jail, provided you, in addition to the interlock, you go to AA, you go for your counseling. On a second offense case, there's mandatory jail of 2 days to 90 days. Plus, and anytime you have a DWI, you have to go to what's called the IDRC, and that's we kind of refer to it as a drunk driving school, IDRC, Intoxicated Driver Resource Center. On a second offense, you got to go for 48 hours. So a good attorney can convince the judge that rather than doing the jail time, you got to convince the judge and the prosecutor, let's do the IDRC. So in a nutshell, those are some of the major changes on the alcohol. Now, what's happened for the past year? Well, the courts have been closed to the public. But the courts are closed to physical. So logistically, how are we handling court? How are we going to court? Well, okay, so someone has a matter, and in a way, many things we made it easier for people. I would always insist that someone make an appointment, come into my office. We would go, and then they would be in the reception area filling out a form by hand, and then I'd be trying to read their handwriting, or they would write down, I don't know, I don't know. Hey, let's make it more efficient. Instead, the attorney emails a questionnaire. Someone's able to spend more time than just a couple minutes in a lobby reception room. They email it back, and then I call the people back, and it goes, okay, listen, if what you've put down again is accurate, this is what I think that we can do. But again, part of it is the accuracy of someone. A fellow today, there's a question: how many prior no-point tickets have you gotten? He puts down none. Well, and we contact the prosecutor. No, he has 2 priors. He's not eligible for a no-point ticket. Okay, so then logistically, we say, okay, listen. Here's what here's the best case scenario. The case is not going to go away. It's not going to be dismissed with a warning. However, what we can do is, this, and this. We tell someone, okay, the fee is, whatever, depending upon the court, the severity, how much work we think we have to do. And then again, to make it easier for people, okay, we're going to do a credit card online. So many of the cases we resolve without me ever seeing the person's face except for Zoom hearings. So, I don't know what some of the people look like until I see their face on Zoom. We also found that people didn't need to see our face for appointments. When other thhave personal injury, they would set up, FaceTime, whatever. Hey, then people, they don't want to, have to dress nice for me. Logistically, what the attorney does next, once they're retained, they prepare a letter of representation to the court, a letter of representation to the prosecutor, and ask for discovery from the prosecutor. Courts didn't want to give out their email prior to COVID. Now they have to, and I kind of set up a database for where I know what the courts don't have a public listing, but I know what they are. So then I'll email the prosecutor, email the court, and then I'll find, many towns have different prosecutors. Once I find out who the prosecutor is, I'll email the prosecutor. Say, okay, listen, here's some of the facts. This is what I propose. And then sometimes we bother the prosecutor. Okay, you didn't get back to us. This is what I propose. Then we bother the prosecutor again. This is what we propose. Some prosecutors are better than others. But if it's resolved, for many cases, for traffic matters, for example, we can have a plea form filled out and a plea online, have the client sign it, send it in. Then they don't even have to go for the Zoom hearing, depending upon the court. Other courts say, we don't care, everyone's going for Zoom. But then when we do the Zoom hearings, there is, court on Zoom. The attorney goes into a breakout room with the prosecutor. We chat. I had court this morning with North Brunswick prosecutor, and we're talking about my dog and other things, and then we go on to the case. Okay, then we go back in front of the judge, and the judge handles the case without anyone seeing us or having to come in. So eventually we're going to be coming back to court, and I goes, hey, listen, okay, I don't want to be having driving throughout the state. Let's say I want to do as many of my cases as possible in the comfort of my own office. I mean, right now I'm not. When I see a judge, I put my suit and tie on. But other than that, when in the nicer weather, the suit's on the back of the chair. Okay, so what's some of the other big things? Well, let me go over a couple quick cases before we talk about expungements. Let's say the appellate division said the failure of the police to advise, in the case of State versus Sims, SIMS, they said the failure of police to advise the defendant of the charges against him would result in the suppression of his statement against Miranda. In State versus what's called NEMA, NYEMA, the appellate division held the mere report of black males robbing a 7-Eleven was not sufficient to stop a car with black males in it nearby, even though they diverted eyes. That's an appellate division case. In the appellate division in State versus Radel, RADEL, they said that the court could not do a what's called a protective search of a car in an area nearby where the defendant was already handcuffed. They needed a search warrant for that. If the defendant's already handcuffed with his hands behind his back, the idea of like doing these protective searches so the defendant couldn't run and get a weapon and hurt the police. Well, if the defendant's hands are both handcuffed behind their back, they're not going to be able to do a protective search. A case out of Middlesex, State versus Chen, PTI cannot be conditioned on jail time. PTI is what's called pre-trial intervention. It's where someone's charged with a indictable felony level offense, but they're a first offender, nonviolent. They can do this program. In municipal court for drug offenses, it's called conditional discharge. For non-drug offenses for first offenders, it's called conditional dismissal. Now, there's also some other recent legislation that takes away the court's power to suspend people's driver's licenses. I mean, that used to be the hammer of all these courts and prosecutors, the threat of, you're going to lose your license, you lose your license. Well, the legislature said, listen, we don't want to be suspending all these people's licenses for penny-ante things or stuff. We want people to have a license so they can work because, they said it was unequal that, rich people weren't affected as much as poor people. Okay, so right this year, there's a Supreme Court directive. No more driver's license suspensions for people who do not show up in court. Before this year, the judges, if someone didn't show up for a disorderly persons offense or an ordinance offense, down the shore, that was a big deal. Someone gets this drinking underage ticket or drinking in public ticket, in Seaside, 60-year-old guy gets a ticket for, having a drink or being on the beach, doesn't show up for court, and the judge will say, okay, suspend their driver's license. Well, fortunately, the legislature did away with that. Prior to this year, it was a mandatory loss of license of 1 year on no insurance. Let's say that was taken away. There used to be mandatory loss of licenses for someone giving a phony ID 20 years old to go to Bar A or DJ's. Mandatory loss of license. No more mandatory loss of license. No more mandatory loss of license on abandoned motor vehicles. And also, they also barred suspending people's licenses for failure to pay on installment order, pay their fines. That used to be a big thing by the courts. Oh, they owe fines? Okay, we're going to suspend their driver's license. Hey, they're poor to begin with. If they had money, they would pay their fine. So it's all about trying to make things equal. Now, another recent thing is the New Jersey's online dispute resolution to let people handle their cases online and contact the prosecutor. I mean, before this COVID thing, you had to plead not guilty, you had to go to court, wait in line for a long period of time, wait to the prosecutor. Now, both defense attorneys and people accused can, through the system, contact the prosecutor ahead of time. Obviously, it's easier for attorneys because I have the prosecutor's direct email, I have their fax number, I have their phone number, and I can bother them a lot easier than someone. Okay, let's talk about expungements. The expungement process was made much easier. So there is an online mechanism for us to process expungements with an online fill in the blank. So for attorneys, we have to log in through eCourts. For non-attorneys, you got to set up an account and try to remember all your offenses. So for a lot of people, though, what I usually say is, listen, if you're not 100% sure of all your prior criminal and ordinance violations, because remember, an ordinance could be that ticket you got in 1987 for peeing in public. Even if it was dismissed, it's still on the record. In towns such as Belmar, the offense wasn't peeing in public. The offense statute's called indecent conduct. And boy, you don't want to be applying for a job and someone does a background search and says, hey, this guy, indecent conduct makes it seem as if you go into a park and like, in a trench coat, doing bad stuff. My concern though with the online system is, the courts say that they're sending out an order to the entities and saying they should do stuff. The positive of the old system was once we got a paper court order, we would send it to the Attorney General's office, the Superintendent of the State Police, the county prosecutor, the local chief of police, the local court, local probation, any other police department involved, and then we would insist upon, written communication, and we would know that until the state police affirmatively sent us a letter saying it was removed, it was still on someone's record. So, but it's kind of the issue is, does someone want to spend the money, to have an attorney do it, or they just kind of want to wing it themselves? A couple other recent cases, let's say lewd gestures, giving the finger to your soon-to-be ex-wife could be a violation of a temporary restraining order. That was State versus EJH by the Appellate Division. In this case, there's a restraining order. The guy can't speak to his wife, contact his wife, communicate to his wife. Well, he's at where his wife's living, knows his camera's outside, gives the bird, goes back, gives the bird again, gives the bird, and the trial judge threw it out, saying, well, he was giving it to the camera, not to her. But the appellate court says, well, it was meant for her to see it, and she would be looking at the camera. Or when you have these rings or security cameras, it then, let's say, it then goes to your phone. So that's State versus EJH. Another recent case, not a municipal court case, but they said in new science such as DNA, the defendant can have scientific evidence such as the marine software source code obtained by the company for their expert to review. That was State versus Pickett. Why this was important was, the state would, have a new scientific theories, and they would say, trust us, it's reliable. Well, at least Pickett said, well, wait. If the defense is going to have an expert, they can be required to provide information on how it's reliable. Okay, DWI cases. Is the court is someone sitting in the parked car with the engine running, operation for the purposes of DWI? Well, in State versus Thompson, the appellate division said yes. Let's say they were parked with the engine running in the store. And the person was found guilty. Now, the attorney's seeking Supreme Court reversal. It's called certification. Now, there's an older case, State versus Dial. And the difference was someone's parked in a Wawa, the engine running. The judge said, well, there's a presumption the person was gonna leave right away after they got it from their nap. In State versus Dial, the car is parked in a bar parking lot. The evidence was the person was not going to drive. They went from the bar to the parking lot, put the engine on because it's a winter time, and in Dial, the judge found the person not guilty. Let's say here's an interesting case. The license plate holders, the plastic thing that holds your license plate. Sometimes it's a vanity plate, Go Giant. Sometimes it's what you got from the dealership, Maloof or whatever, and a little tiny part of the bottom would cover up a little tiny bit of, Garden State on the driver's license. The police used to use this at nighttime as pretextual stops to pull someone over. Oh, the license plate was obstructed, and interestingly, the appellate division in State versus Roman Rosado said, no, listen. the fact that if all the numbers can be seen in the license plate, that's sufficient. And so they agreed the stop should have been, it was a phony stop. The license should have been, the stop should have been oppressed, and the person got a free one. Because when they did search the car, they found a whole lot of serious criminal stuff. Okay, let's go back to talking about DWI, DRE in drug cases. The police have what they call trained police officers called DREs, drug recognition evaluators. But there's a Supreme Court remand in the case State versus Olenowski, spelled Olenoski, where it was remanded to a special master on the reliability and admissibility of this drug recognition evaluation evidence, because it was discovered that the Attorney General's office did not have any specific guidelines on how people were to be trained. In DWI cases, there's specific guidelines, and administrative regs have some. In these DRE cases, drug recognition evaluations, it was the International Chiefs of Police, which isn't even a New Jersey entity, was permitting cards to be passed out. And the thing that the court noticed was that they weren't, in part of the training, they were told ahead of time what the person had consumed. So they were told, okay, this person took meth. So the evaluator would do these things and say, in my opinion, it's meth. Okay, they would say, okay, this person took some heroin. Okay, my opinion, there was heroin. There was no blind studies done to really test how good they were. So I remember years ago, I had heel problems, and I knew what one doctor said, but I didn't tell the next doctor what the prior one said. I wanted to see if he could figure it out for himself, because otherwise he would just confirm what the other person said. And I was kind of glad the next doctor was right. Okay, so that's State versus Olenowski. We've been waiting, over a year on this, but because of COVID, everything's put on the back burner. Now, another interesting case is State versus Cassidy, and this deals with old DWI cases in Monmouth, Middlesex, some of the cases. So in this State versus Cassidy case, they looked at the troopers that tested the machine, or one particular trooper. If they didn't do the required testing, doesn't that make inadmissible all of the alcohol or the alcohol test results, and therefore shouldn't everyone's DWI be vacated? So the facts were one of the coordinators was this Trooper Dennis, and the Supreme Court had directed some years ago that in order for a DWI test to be admissible, it had to be tested using something called a mistraceable thermometer, because the chemicals they used had to be different temperatures. Well, it was discovered that in some of the cases, this Trooper Dennis wasn't doing it. He was busy, didn't want to do it, didn't want to be bothered. He was eventually indicted for falsifying reports, saying he did the results and did the tests right and didn't do them. So now there's anywhere between 15,000, 18,000 cases where the Supreme Court had assigned 4 recall judges to eventually determine whether or not all these DWIs should be thrown out or what should be done. Well, we've been waiting a year and a half for some action, but because of COVID, everything else, waiting. Let's say I've already mentioned that the new DWI statute started effective. It was effective actually December 1, 2019. An interesting issue is, let's say someone had a case that was from December 29th, 2019. And someone says, "Hey, I want the penalties under the new one, not under the old one." I'd say, well, there's still some judges were saying, "I agree, you should be entitled to the new statute. Some other judges said no. There's one unreported decision that says no. We're waiting for a reported decision. I got some cases that are also like this that are pending. Okay, last couple cases. Can the police run someone's license plate, while they're just tooling down the road, and then if the owner's license plate, driver's license is revoked, can they pull the car over? United States Supreme Court in Kansas versus Glover said yes, they can. And some of the police cars have a thing called mobile display readers, where the police can just tool around and it reads license plates and it sends it into a database, and it'll pop back if the if the owner's license is suspended, or if the registration privileges are suspended. So both the United States Supreme Court and New Jersey courts have found that's probable cause. And so let's say with that, that's those are some of the major updates in the drug law in New Jersey. Legally you can't buy. Interesting, you can buy drugs in New Jersey legally. Let's see, but you can't be punished for possessing them. So someone stole the sarcastic thing, someone still has to go drive up in an inner city place, or go to the friend that they knew to buy, or take the train for a day up to Boston, buy your edibles. Oh, interesting, in New Jersey, by the way, edibles have to look like something that is not a gummy, can't look like candy, because in Massachusetts they found little kids were eating them because they thought they were gummies, and they were getting high. So if you want your gummies, you got to go to Massachusetts to get them. I'm not sure if you can. DC decriminalized things. So my name is Ken Vercammen. I'm an attorney in Edison, New Jersey, on Woodbridge Avenue in Edison, not that far from Middlesex County College. But everything now we see people quote remote, which is really by phone and online, etc. So I'd say the bad advice I gave to the Catholic school kids was don't get caught, and the nuns at the high school didn't like that. But don't be careful, don't get caught. I'm shocked by the number of people that when it was legal, they would leave their weed on the dashboard. And still I see idiots leaving their their coke on the dashboard or the cut or whatever, because hey, you put it in the trunk. They can't search the trunk unless you're stupid enough to sign a consent to search form.